Question 1. Which approach would be most appropriate for a South Carolina concealed weapon permit instructor when evaluating an applicant who has a documented arrest for assault and battery, but the charges were later dismissed, and the applicant has otherwise met all statutory requirements for the permit? Option A. Issue the permit without further inquiry, assuming the dismissed charges mean the applicant is fully qualified. Option B. Rely solely on the applicant's self-reported history and character references, without investigating the dismissed arrest. Option C. Immediately deny the permit application because any arrest, regardless of dismissal, indicates a potential risk. Option D. Conduct a thorough review of the applicant's entire background, including the circumstances surrounding the dismissed charge, to assess their overall character and fitness for carrying a concealed weapon. Correct answer is D. Conduct a thorough review of the applicant's entire background, including the circumstances surrounding the dismissed charge, to assess their overall character and fitness for carrying a concealed weapon. Explanation. This scenario presents a professional challenge because it requires an individual to balance their right to self-defense with the legal obligations and responsibilities associated with carrying a concealed weapon in South Carolina. The applicant's past behavior, while not resulting in a conviction, raises concerns about their judgment and temperament, which are critical factors in determining suitability for a concealed weapon permit, CWP. A careful and thorough risk assessment is paramount to ensure public safety and uphold the integrity of the permitting process. The best approach involves a comprehensive review of all submitted documentation, including any relevant background information that may not have resulted in a conviction, but indicates potential risk factors. This approach prioritizes a holistic evaluation of the applicant's suitability by considering not just legal disqualifiers, but also behavioral indicators that could impact responsible firearm ownership. South Carolina law, specifically the statutes governing CWP issuance, mandates that the issuing authority consider the applicant's character and fitness. While a past arrest without a conviction is not an automatic disqualifier, it necessitates further scrutiny to assess the applicant's current disposition and potential for misuse. This thorough review aligns with the ethical responsibility to protect the public by ensuring that only individuals demonstrating sound judgment and a commitment to responsible firearm handling are granted a permit. An approach that dismisses the applicant solely based on an arrest without a conviction, regardless of the circumstances or the outcome of that arrest, fails to adhere to the nuanced requirements of South Carolina law. The law allows for discretion in issuing permits when an applicant's character and fitness are in question, but this discretion must be exercised based on a thorough assessment, not a blanket rejection of any past legal entanglement. Another unacceptable approach would be to grant the permit without any further consideration of the arrest, assuming that the absence of a conviction negates any potential risk. This overlooks the possibility that the underlying behavior leading to the arrest, even if not prosecuted to a conviction, might still indicate a propensity for actions that are incompatible with the safe and responsible carrying of a concealed weapon. Finally, an approach that relies solely on the applicant's self-reporting without independent verification or consideration of any available background information would be negligent. The permitting process is designed to be a safeguard, and relying solely on an applicant's potentially biased self-assessment undermines this crucial function. Professionals in this situation should employ a decision-making framework that begins with understanding the specific legal requirements for CWP issuance in South Carolina. This includes identifying both automatic disqualifiers and factors that warrant further investigation. The framework should then involve gathering all relevant information, conducting a balanced assessment of the applicant's overall suitability, and making a determination based on the totality of the circumstances, always prioritizing public safety and adherence to the law. Question 2. Investigation of an applicant's understanding of South Carolina's concealed weapon permit laws reveals they believe that as long as a handgun is kept out of sight, they can carry it anywhere in South Carolina, provided they have a valid CWP. Which of the following approaches best reflects the necessary risk assessment for this applicant's knowledge regarding prohibited locations? Option A. The applicant should be assessed on their general awareness of firearm safety and responsible gun ownership principles. Option B. The applicant's knowledge is sufficient if they can articulate the importance of keeping the weapon concealed from public view. Option C. The applicant must demonstrate a detailed understanding of specific locations explicitly prohibited by South Carolina law, regardless of signage, such as schools, courthouses, and polling places on Election Day, as outlined in the South Carolina Code of Laws. Option D. The applicant's understanding is adequate as long as they do not openly display the firearm and are not explicitly told by an authority figure that they cannot carry it in a particular location. The correct answer is C. The applicant must demonstrate a detailed understanding of specific locations explicitly prohibited by South Carolina law, regardless of signage, such as schools, courthouses, and polling places on Election Day, as outlined in the South Carolina Code of Laws. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to balance the legal right to carry a concealed weapon with the responsibility to ensure public safety and adhere to specific South Carolina CWP regulations. Misinterpreting or disregarding these regulations can lead to denial of the permit, legal repercussions, and potential safety risks. The applicant must demonstrate a thorough understanding of the legal framework governing concealed carry in South Carolina, particularly concerning the types of locations where carrying a concealed weapon is prohibited. Correct approach analysis. The best professional practice involves a comprehensive review of South Carolina Code of Laws, specifically Title 16, Chapter 23, Article 4, which governs concealed weapons. This approach ensures the applicant understands the explicit prohibitions, such as carrying a handgun in a school, courthouse, or polling place on Election Day, and other locations where notice of prohibition is posted. Adhering strictly to these codified restrictions is paramount for a successful and lawful CWP application. This approach directly addresses the legal requirements and demonstrates a commitment to responsible gun ownership as mandated by South Carolina law. Incorrect approaches analysis. One incorrect approach involves relying solely on general knowledge or anecdotal information about gun laws. This is professionally unacceptable because it bypasses the specific statutory language and judicial interpretations that define prohibited locations in South Carolina. General knowledge is often incomplete and can lead to dangerous misunderstandings of the law, potentially resulting in carrying a weapon in a prohibited area, which is a criminal offense. Another incorrect approach is to assume that if a location does not have a specific sign prohibiting firearms, it is permissible to carry a concealed weapon. This fails to recognize that South Carolina law explicitly lists certain locations where carrying a handgun is prohibited regardless of signage, such as schools and courthouses. This approach demonstrates a lack of due diligence in understanding the full scope of the law. A further incorrect approach is to focus only on the physical act of concealing the weapon and ignore the legal restrictions on where it can be carried. This is a critical failure as the CWP is not merely about the ability to hide a firearm, but about the legal authorization to carry it in specific circumstances and locations. Ignoring these restrictions negates the purpose of the CWP and exposes the applicant to legal jeopardy. Professional reasoning. Professionals seeking a South Carolina concealed weapon permit should adopt a systematic approach. First, they must identify and thoroughly study the relevant South Carolina statutes and regulations pertaining to concealed carry. Second, they should cross-reference this legal knowledge with practical scenarios to understand how the law applies in real-world situations. Third, they should seek clarification from official sources, such as the South Carolina Law Enforcement Division, SLED, if any aspect of the law remains unclear. This methodical process ensures compliance and promotes responsible firearm ownership. Question 3. Assessment of an applicant's personal history for a South Carolina Concealed Weapon Permit, CWP, requires careful consideration of potential disqualifying factors. If an applicant has a past misdemeanor conviction for simple assault that occurred over 10 years ago and was subsequently expunged from their record, what is the most prudent approach to determining their eligibility for a CWP in South Carolina? Option A. Proactively research South Carolina Code of Laws pertaining to CWP eligibility and the specific impact of expunged misdemeanor convictions on such applications, and if necessary, consult with the South Carolina Law Enforcement Division, SLED, for definitive guidance. Option B. Focus on the applicant's stated need for self-defense and the fact that the offense was minor, believing these factors will outweigh any past legal issues. Option C. Rely on the advice of a friend who also has a CWP and was told that expunged records are always disregarded for CWP purposes. Option D. Assume that because the conviction was a misdemeanor, occurred long ago, and was expunged, it will not affect their CWP eligibility. The correct answer is A. Proactively research South Carolina Code of Laws pertaining to CWP eligibility and the specific impact of expunged misdemeanor convictions on such applications, and if necessary, consult with the South Carolina Law Enforcement Division, SLED, for definitive guidance. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to balance their right to self-defense with the legal obligations and responsibilities associated with carrying a concealed weapon in South Carolina. The applicant's personal circumstances, while understandable, must be evaluated against the strict legal requirements for obtaining and maintaining a concealed weapon permit, CWP. Misinterpreting or disregarding these requirements can lead to permit denial, revocation, and potential legal repercussions. Correct approach analysis. The best professional approach involves a thorough and honest self-assessment of one's eligibility based on South Carolina law, specifically focusing on the grounds for disqualification outlined in the South Carolina Code of Laws. This includes a candid review of any past criminal convictions, mental health adjudications, or substance abuse issues that could legally prevent permit issuance. The applicant must proactively gather documentation to demonstrate they meet all statutory requirements and are not subject to any disqualifying factors. This approach aligns with the ethical duty to uphold the law and ensure public safety, as mandated by the CWP program's intent. Incorrect approaches analysis. One incorrect approach is to assume that a past minor offense, even if expunged, will not be a barrier without verifying its specific impact under South Carolina CWP law. South Carolina law has specific provisions regarding expunged offenses and their effect on CWP eligibility, and a blanket assumption is legally unsound. Another incorrect approach is to focus solely on the perceived need for self-defense, without adequately researching the legal definitions of good moral character and other eligibility criteria as defined by South Carolina statutes. CWP is a privilege granted based on meeting specific legal standards, not solely on a subjective assessment of need. A further incorrect approach is to rely on anecdotal information or the experiences of others regarding CWP eligibility without consulting the official South Carolina Code of Laws or seeking guidance from the South Carolina Law Enforcement Division, SLED. Legal requirements are precise and can vary significantly, making informal advice unreliable and potentially detrimental. Professional reasoning. Professionals in this context, such as CWP instructors or legal advisors, should guide applicants through a structured assessment process. This process begins with clearly identifying the relevant South Carolina statutes governing CWP eligibility. Applicants should be encouraged to conduct a personal pre-audit of their history against these statutes, focusing on potential disqualifiers. If any potential issues arise, the professional should advise seeking clarification from SLED or qualified legal counsel rather than making assumptions. The ultimate goal is to ensure the applicant's application is legally sound and ethically responsible, prioritizing compliance with South Carolina law. Question 4. The audit findings indicate that a South Carolina concealed weapon permit holder, while briefly leaving their vehicle to enter a store, placed their handgun on the passenger seat, partially covered by a jacket. Considering South Carolina law, what is the most legally compliant and professionally responsible action the permit holder should have taken? Option A. Place the handgun unsecured in the glove compartment before exiting the vehicle. Option B. Leave the handgun on the passenger seat, partially covered by a jacket, as it is not in plain view. Option C. Secure the handgun in a locked container out of plain view within the vehicle or in the trunk before exiting the vehicle. Option D. Carry the handgun openly into the store, assuming the permit allows for carrying a weapon. The correct answer is C. Secure the handgun in a locked container out of plain view within the vehicle or in the trunk before exiting the vehicle. Explanation. The audit findings indicate a potential lapse in adherence to South Carolina's Concealed Weapon Permit (CWP) regulations, specifically concerning the proper storage and transportation of a handgun when not under the direct control of the permit holder. This scenario is professionally challenging because it requires an individual to balance personal convenience with strict legal obligations designed to ensure public safety and prevent unauthorized access to firearms. Misinterpreting or neglecting these regulations can lead to severe legal consequences, including CWP revocation and criminal charges, and can also contribute to the risk of firearms falling into the wrong hands. The best professional approach involves understanding and strictly adhering to South Carolina Code of Laws Section 16-23-460, which governs the carrying of concealed weapons. This statute mandates that a handgun must be carried in a holster or purse and must be either on the person or within the immediate control of the permit holder. When leaving a vehicle, a handgun must be secured in a locked container out of plain view or in the trunk of the vehicle. Therefore, the most appropriate action is to secure the handgun in a locked container within the vehicle, out of plain view, or in the trunk, before exiting the vehicle. This directly complies with the legal requirement to ensure the firearm is not readily accessible to unauthorized individuals. An incorrect approach would be to leave the handgun on the seat of the vehicle, even if it is partially covered by a jacket. This fails to meet the locked container or out of plain view requirement as interpreted by the statute's intent to prevent easy access. Another incorrect approach is to carry the handgun openly into a business that does not permit firearms, as this violates the concealed nature of the permit and potentially other signage or laws regarding open carry. Finally, leaving the handgun unsecured in the glove compartment, which is often not considered a locked container in the context of firearm storage laws and can be easily accessed, is also a violation. Professionals should employ a decision-making framework that prioritizes a thorough understanding of the specific South Carolina CWP laws and regulations. This involves consulting the official South Carolina Code of Laws and any relevant guidance from the South Carolina Law Enforcement Division. SLED. When faced with a situation requiring firearm transport or storage, the professional should ask, does this action comply with South Carolina Code of Laws Section 16-23-460 regarding concealed handguns when not on my person? If there is any doubt, the safest and legally compliant course of action is to err on the side of caution and ensure the firearm is stored in a manner that unequivocally meets the statutory requirements. Question 5. The audit findings indicate that a South Carolina concealed weapon permit holder who legally possesses a handgun has been storing it in their vehicle's glove compartment when not carrying it. The glove compartment is locked, but the vehicle is often parked in a driveway accessible to children. Considering South Carolina law and best practices for firearm safety and risk management, which of the following approaches represents the most responsible and legally compliant method for storing the firearm when not in immediate possession? Option A. Leave the firearm in the locked glove compartment of the vehicle, assuming that children will not be able to access the vehicle unsupervised. Option B. Secure the firearm in a locked container that is inaccessible to children, such as a gun safe or a locked case, and store it in a location within the residence that is not easily accessible to minors. Option C. Continue storing the firearm in the locked glove compartment of the vehicle, as it is locked and therefore provides a reasonable level of security. Option D. Store the firearm in a common area of the home, such as a living room end table, to ensure quick access in case of an emergency. Correct answer is B. Secure the firearm in a locked container that is inaccessible to children, such as a gun safe or a locked case, and store it in a location within the residence that is not easily accessible to minors. Explanation. The audit findings indicate a potential lapse in judgment regarding the storage of a legally possessed firearm. This scenario is professionally challenging because it requires balancing the individual's right to self-defense with the responsibility to ensure public safety and adhere to specific legal requirements for firearm storage. Misinterpreting or neglecting these requirements can lead to serious legal consequences and compromise safety. The best professional practice involves understanding and strictly adhering to South Carolina law regarding the storage of concealed handguns when not on one's person. This includes ensuring the firearm is secured in a manner that prevents unauthorized access, particularly by minors. South Carolina law, specifically S.C. Code Ann. Section 16-23-460 addresses the unlawful carrying of a handgun and, by extension, the responsible storage when not carried. While the law primarily focuses on carrying, the underlying principle of preventing unauthorized access is paramount. Therefore, securing the firearm in a locked container or a location inaccessible to children is the most prudent and legally compliant approach. This directly addresses the risk of accidental discharge or unauthorized use by individuals who are not permitted to possess a firearm. Leaving a firearm unsecured in a vehicle, even if locked, presents a significant risk. South Carolina law, while not explicitly detailing vehicle storage for permit holders in all scenarios, emphasizes responsible handling and preventing access by prohibited persons. The risk of theft from a vehicle is substantial, and if stolen, the firearm could be used in criminal activity, leading to severe legal repercussions for the owner. Furthermore, if a minor gains access to an unsecured firearm in a vehicle, it constitutes a failure to exercise due care and could violate child access prevention laws or general negligence principles. Storing a firearm in a location accessible to children, such as a bedside table drawer that is not locked, directly contravenes the principle of preventing unauthorized access, especially by minors. This creates an immediate and unacceptable risk of accidental injury or death. While South Carolina law may not have a specific child access prevention statute as detailed as some other states, the general duty of care and the potential for criminal negligence or endangerment charges exist when a firearm is accessible to children. Placing a firearm in a common area of the home where children might discover it, even if the intent is to keep it readily accessible for self-defense, is a failure to adequately secure the weapon. The audit findings suggest a need for a more robust risk assessment of the storage location. The primary concern is preventing unauthorized access, and a common area by its nature is more likely to be accessed by children or other unauthorized individuals than a locked container or a designated secure location. Professionals facing similar situations should adopt a decision-making framework that prioritizes legal compliance and risk mitigation. This involves 1. Identifying all applicable state laws and regulations concerning firearm possession, carrying, and storage. 2. Conducting a thorough risk assessment of the proposed storage location, considering potential unauthorized access, especially by minors or through theft. 3. Consulting legal counsel or relevant authorities if there is any ambiguity regarding storage requirements. 4. Implementing the most secure and legally compliant storage method available, even if it requires additional effort or expense, to ensure the safety of others and avoid legal liability. Question 6. The audit findings indicate that a South Carolina concealed weapon permit holder residing in a household with minors stored their legally owned handgun on a bedside table overnight without a locking device. What is the most appropriate immediate course of action for the permit holder to mitigate potential risks and ensure compliance with South Carolina law? Option A. Immediately secure the handgun in a locked safe or case, and then review South Carolina Code of Laws regarding safe storage of handguns, especially in residences with children. Option B. Leave the handgun on the bedside table, as it is legally owned by a permit holder and not in plain view. Option C. Assume that other responsible adults in the household will ensure the handgun is not accessed by minors. Option D. Immediately dispose of the handgun to eliminate any potential risk. The correct answer is A. Immediately secure the handgun in a locked safe or case, and then review South Carolina Code of Laws regarding safe storage of handguns, especially in residences with children. Explanation. The audit findings indicate a potential lapse in judgment regarding the storage of a legally owned firearm. This scenario is professionally challenging because it requires balancing the right to self-defense with the responsibility of secure firearm storage to prevent unauthorized access, especially in a shared living environment. The core issue is not the legality of ownership, but the risk associated with its accessibility. The best professional approach involves immediately securing the firearm in a manner that prevents unauthorized access, such as a locked safe or case, and then reviewing the South Carolina Code of Laws regarding safe storage of handguns, particularly when minors may be present. This proactive step addresses the immediate safety concern and ensures compliance with state regulations designed to prevent accidental shootings or theft. South Carolina law, while not mandating specific safe storage devices in all circumstances, emphasizes the responsibility of the permit holder to prevent access by prohibited persons. The focus is on preventing harm and maintaining responsible gun ownership. An incorrect approach would be to assume that because the firearm is legally owned and the individual is a permit holder, no further action is necessary. This overlooks the critical aspect of risk assessment and the potential for negligence if the firearm is left unsecured and accessible to others, including children or individuals who are not legally permitted to possess a firearm. This failure to act proactively to mitigate risk could have severe legal and ethical consequences, potentially leading to charges if an incident occurs. Another incorrect approach is to rely solely on the verbal assurance of other adults in the household that they will ensure the firearm is not accessed. While well-intentioned, this shifts responsibility without concrete preventative measures. The permit holder remains ultimately responsible for the secure storage of their firearm, and verbal agreements do not constitute a legally defensible safeguard against unauthorized access, particularly in situations involving minors. This approach fails to implement a robust security measure. Finally, an incorrect approach would be to immediately dispose of the firearm without consulting legal counsel or understanding the implications of such an action. While seemingly a drastic measure to eliminate risk, it may not be legally required and could have unintended consequences regarding property rights or future legal standing. The focus should be on responsible management and secure storage, not hasty disposal unless legally mandated or advised by legal counsel. Professionals should employ a decision-making framework that prioritizes immediate safety, followed by a thorough review of applicable laws and regulations. This involves identifying potential risks, implementing preventative measures that are both effective and legally compliant, and documenting all actions taken. In situations involving firearms, a conservative approach that errs on the side of caution and prioritizes the prevention of harm is always the most prudent course of action. Question 7. The audit findings indicate that a South Carolina concealed weapon permit, CWP, holder, after legally purchasing a handgun, stored it in the unlocked glove compartment of their privately owned vehicle while attending a public event. Considering the principles of responsible firearm ownership and South Carolina law, which of the following storage methods best aligns with the expected standard of care for a CWP holder? Option A. Storing the handgun in a locked container that is separate from the passenger compartment of the vehicle. Option B. Leaving the handgun in the unlocked glove compartment of the vehicle. Option C. Storing the handgun in the center console of the vehicle, which is also unlocked. Option D. Placing the handgun in a bag on the passenger seat of the vehicle. Correct answer is A. Storing the handgun in a locked container that is separate from the passenger compartment of the vehicle. Explanation. The audit findings indicate a potential lapse in judgment regarding the storage of a legally owned firearm. This scenario is professionally challenging because it requires balancing the right to self-defense with the responsibility to ensure public safety and adhere to specific legal requirements for firearm storage. A CWP holder in South Carolina is entrusted with the privilege of carrying a concealed weapon, which comes with a heightened duty of care. The core of the challenge lies in interpreting and applying South Carolina law concerning the secure storage of firearms when not in immediate possession, especially in a shared or public access environment. The best professional practice involves prioritizing the secure storage of the firearm in a manner that prevents unauthorized access, even if the individual believes the risk is low. This approach recognizes that the legal framework for concealed carry in South Carolina, while permitting lawful carrying, also imposes obligations on the permit holder to prevent negligent storage or access by others. Specifically, South Carolina Code of Laws Section 16-23-460 addresses the unlawful carrying of handguns, and while not explicitly detailing storage in all private vehicles, the spirit of responsible firearm ownership and the potential for theft or unauthorized use necessitate a secure method. A locked container, separate from the passenger compartment if possible, or a secure locking device integrated into the vehicle, best mitigates the risk of theft or accidental discovery and use by unauthorized individuals. This aligns with the ethical imperative to act with due diligence and prevent foreseeable harm. An incorrect approach would be to leave the firearm in plain view or unsecured in the passenger compartment of the vehicle. This fails to meet the standard of reasonable care and significantly increases the risk of theft, which could lead to the firearm being used in criminal activity. Such an action directly contravenes the responsible handling expected of a CWP holder and could be interpreted as negligent storage under broader legal principles, even if not explicitly detailed for every vehicle scenario in the statute. Another incorrect approach would be to store the firearm in a glove compartment that is not locked, while seemingly out of sight, An unlocked glove compartment offers minimal security against determined individuals or opportunistic theft. This method does not provide adequate protection against unauthorized access and therefore fails to meet the responsible storage expectations. Finally, an incorrect approach would be to assume that because the vehicle is locked, the firearm is sufficiently secured. A locked vehicle alone does not prevent theft, especially if the firearm is visible or easily accessible once entry is gained. The legal and ethical expectation is for a more robust security measure that actively prevents unauthorized access to the weapon itself. Professionals should employ a decision-making framework that begins with understanding the specific legal requirements for firearm storage in South Carolina, even in nuanced situations like vehicle storage. This should be followed by a risk assessment that considers the potential for theft, unauthorized access, and the consequences of such events. The chosen storage method should be the most secure option available that complies with the law and effectively mitigates identified risks, prioritizing public safety and responsible firearm ownership. Question 8. The audit findings indicate that a South Carolina concealed weapon permit holder, while briefly stepping away from their vehicle in a parking lot, left their handgun unsecured in the glove compartment. Which of the following actions best demonstrates compliance with South Carolina's concealed weapon regulations? Option A. Leaving the handgun in the glove compartment, assuming the vehicle is locked and the area is generally safe. Option B. Placing the handgun in a backpack on the passenger seat, out of plain view. Option C. Entrusting the handgun to a companion who is not a CWP holder to hold while the permit holder is away from the vehicle. Option D. Immediately securing the handgun in a locked container within the vehicle that is not readily accessible to unauthorized individuals. The correct answer is D. Immediately securing the handgun in a locked container within the vehicle that is not readily accessible to unauthorized individuals. Explanation. The audit findings indicate a potential lapse in adherence to South Carolina's Concealed Weapon Permit (CWP) regulations, specifically concerning the proper storage and handling of a firearm when not under direct control. This scenario is professionally challenging because it requires an individual to balance personal convenience with strict legal obligations designed to ensure public safety and prevent unauthorized access to firearms. A failure to comply can have severe legal consequences, including permit revocation and criminal charges, as well as ethical implications regarding responsible gun ownership. The best professional practice involves prioritizing immediate, secure storage of the firearm in a manner that prevents unauthorized access, even if it causes minor inconvenience. This approach directly aligns with the spirit and letter of South Carolina law, which emphasizes that a concealed weapon must be under the permit holder's direct, continuous control or secured when not in their immediate possession. This ensures the weapon is not accessible to children, other unauthorized individuals, or easily taken during a moment of distraction. An approach that involves leaving the firearm unsecured in a vehicle, even if out of plain sight, represents a significant regulatory failure. South Carolina law requires that a handgun carried in a vehicle be secured in a locked container or compartment, or in a manner that it is not readily accessible to the driver or passengers. Leaving it in a glove compartment or under a seat without a locking mechanism, or in a bag that is not locked, violates this requirement and creates an unacceptable risk of theft or unauthorized use. Another unacceptable approach is to leave the firearm in a location where it is not under the permit holder's direct control and is accessible to others, such as on a table in a public area while stepping away briefly. This directly contravenes the principle of continuous control or secure storage mandated by South Carolina law. It demonstrates a lack of awareness or disregard for the responsibility that comes with carrying a concealed weapon. Finally, an approach that relies on the assumption that the location is safe or that no one will interfere with the firearm is also professionally unsound. Legal compliance and responsible gun ownership are not based on assumptions, but on adherence to established safety protocols and legal mandates. The law does not permit subjective assessments of safety to override explicit storage requirements. Professionals should employ a decision-making framework that begins with a thorough understanding of South Carolina's CWP laws and regulations regarding firearm storage and handling. When faced with a situation requiring temporary firearm storage, the primary consideration must be legal compliance and risk mitigation. This involves identifying the most secure and legally compliant storage option available, even if it requires extra effort or time. If there is any doubt about the legality or safety of a particular storage method, the individual should err on the side of caution and seek an alternative that unequivocally meets legal standards. Question 9. Compliance review shows a licensed South Carolina real estate agent who also holds a valid concealed weapon permit, CWP, is scheduled to conduct a private home showing. The agent plans to carry their concealed firearm during the showing. What is the most professionally responsible and legally prudent course of action for the agent to take regarding their CWP and the upcoming showing? Option A. Assume that since carrying a concealed weapon is legal for a CWP holder, no notification is necessary, and proceed with the showing without mentioning the weapon. Option B. Enter the private residence for the showing without informing the property owner or listing agent about carrying a concealed weapon. Option C. Conceal the fact that one possesses a CWP and is carrying a concealed weapon, and only reveal it if directly questioned or if an incident occurs. Option D. Proactively inform the property owner or listing agent that they will be present for the showing and will be carrying a concealed weapon, seeking their explicit consent. Correct answer is D. Proactively inform the property owner or listing agent that they will be present for the showing and will be carrying a concealed weapon, seeking their explicit consent. Explanation. Scenario analysis. This scenario presents a professional challenge for a CWP holder in South Carolina who is also a licensed real estate agent. The core conflict lies in balancing the right to carry a concealed weapon with the professional responsibilities and potential liabilities associated with entering private residences during business hours. The agent must navigate South Carolina law regarding concealed carry, property rights, and the specific regulations or ethical considerations governing real estate transactions, all while ensuring public safety and maintaining professional integrity. The challenge is amplified by the potential for misinterpretation of intent by homeowners or law enforcement, and the need to avoid any action that could be construed as intimidating or threatening, even if unintentional. Correct approach analysis. The best professional practice involves proactively communicating with the property owner or listing agent prior to entering a private residence for a showing. This approach ensures transparency and obtains explicit consent for the CWP holder to be present with a concealed weapon. This aligns with the principle of respecting property rights and avoiding any appearance of impropriety. South Carolina law permits concealed carry for permit holders, but professional conduct and ethical considerations in a business context necessitate open communication to prevent misunderstandings and potential conflicts. Informing the relevant parties demonstrates responsible gun ownership and professional courtesy, mitigating risks and fostering trust. Incorrect approach is analysis. One incorrect approach is to enter the private residence for a showing without informing the property owner or listing agent about carrying a concealed weapon. This fails to respect the homeowner's right to know who is entering their property and under what circumstances. While South Carolina law may not explicitly require such notification for CWP holders entering a private residence for legitimate business, the absence of communication creates a significant risk of alarm or suspicion, potentially leading to a complaint or confrontation. It also bypasses professional courtesy and transparency expected in real estate dealings. Another incorrect approach is to assume that because carrying a concealed weapon is legal for a CWP holder, no notification is necessary, and to proceed with the showing as if the weapon's presence is irrelevant. This overlooks the ethical dimension of professional conduct. Real estate agents are entrusted with access to private homes and have a duty to act in a manner that upholds the trust of clients and the public. Failing to disclose a concealed weapon, even if legally carried, can be perceived as a lack of consideration for the homeowner's peace of mind and could damage the agent's professional reputation and the reputation of the real estate industry. A further incorrect approach is to conceal the fact that one possesses a CWP and is carrying a concealed weapon, and to only reveal it if directly questioned or if an incident occurs. This is a reactive and potentially damaging strategy. It implies an intent to deceive or to avoid scrutiny, which is unprofessional. Furthermore, if the weapon were to be discovered inadvertently, the lack of prior disclosure could be interpreted negatively, even if the carrying of the weapon was legal. Proactive communication is always a more ethical and professional stance. Professional reasoning. Professionals in South Carolina, particularly those in roles involving access to private property like real estate agents who also hold a CWP, should adopt a decision-making framework that prioritizes transparency, respect for property rights, and adherence to both legal requirements and ethical standards. When faced with a situation involving carrying a concealed weapon in a professional capacity, the primary consideration should be how to conduct oneself in a manner that is both legally compliant and professionally responsible. This involves anticipating potential concerns from others and proactively addressing them through clear and open communication. The framework should involve 1. Understanding the legal rights and responsibilities related to concealed carry in South Carolina. 2. Recognizing the professional duties and ethical obligations inherent in the specific role, e.g., real estate agent. 3. Assessing potential risks and liabilities associated with the intersection of these two aspects. 4. Prioritizing open communication and obtaining consent where appropriate to ensure all parties are comfortable and informed. 5. Acting with integrity and professionalism at all times to maintain trust and uphold professional standards. Question 10. The monitoring system demonstrates a need to verify the legal transport of a concealed handgun within a vehicle in South Carolina. A CWP holder is driving their vehicle and wishes to transport a handgun that is not on their person. The handgun is unloaded and the ammunition is stored separately. To ensure compliance with South Carolina Code of Laws Section 16-23-460, the CWP holder measures the distance from the driver's seat to the nearest exterior point of the vehicle. If this distance is calculated to be 3 feet, what is the most legally sound placement for the unloaded handgun to be considered not on or about the person and therefore compliant with the statute? Option A, placed on the passenger seat in plain view. Option B, placed on the floorboard directly in front of the driver's seat within immediate reach. Option C, placed in the glove compartment which is within arm's reach of the driver's seat. Option D, placed on the floorboard behind the driver's seat, at least 3 feet from the driver's seat. The correct answer is D, placed on the floorboard behind the driver's seat, at least 3 feet from the driver's seat. Explanation. The monitoring system demonstrates a need for careful consideration of South Carolina's Concealed Weapon Permit, CWP, regulations, particularly concerning the permissible carry of a handgun in a vehicle. The scenario presents a common challenge for CWP holders, understanding the precise legal boundaries when transporting a firearm. This requires not just knowledge of the law, but also the ability to apply it to a specific, potentially ambiguous situation. The professional challenge lies in ensuring compliance with South Carolina Code of Laws Section 16-23-460, which governs the carrying of handguns in vehicles, while also upholding the responsibility that comes with carrying a concealed weapon. The best approach involves a precise calculation of the distance from the driver's seat to the nearest point of the vehicle's exterior. South Carolina law, specifically Section 16-23-460, states that a person may carry a handgun in a vehicle if it is not carried in any holster but is separated from the ammunition and is not on the person of the person. Crucially, it also allows for the handgun to be in plain view or concealed on or about the person if the person is in a vehicle and the handgun is not on or about the person. The most restrictive interpretation, and thus the safest for compliance, is to ensure the handgun is not on the person at all and is separated from ammunition. The distance calculation is critical because if the handgun is found to be on or about the person, which can be broadly interpreted to include within immediate reach or control, and not in plain view, it could lead to a violation. Therefore, ensuring the handgun is placed in a location that is demonstrably not on or about the person, by maintaining a significant distance from the driver's immediate control, is the most prudent method. The calculation of 3 feet, 36 inches from the driver's seat to the nearest exterior point of the vehicle is a conservative measure to ensure the handgun is not considered on or about the person, in a way that would violate the spirit or letter of the law, especially if it's not in plain view. This distance creates a clear separation, mitigating the risk of it being construed as immediately accessible or carried on the person. An incorrect approach would be to assume that simply placing the handgun in the glove compartment is sufficient without considering its proximity to the driver. The glove compartment is often within immediate reach, and if the handgun is loaded and readily accessible, it could be interpreted as being on or about the person under certain circumstances, especially if not in plain view. This fails to account for the nuanced interpretation of on or about the person and the importance of clear separation. Another incorrect approach is to rely on the handgun being in plain view as the sole determinant of legality. While plain view is a factor, the law also addresses whether the handgun is on or about the person. If a handgun is in plain view but still within immediate reach and control of the driver, it could still be problematic if not properly secured or separated from ammunition, depending on the specific circumstances and interpretation. This approach overlooks the on or about the person clause and the requirement for separation from ammunition. A further incorrect approach would be to assume that any distance from the driver's seat, no matter how small, automatically satisfies the law. The law implies a degree of separation that removes the handgun from immediate, direct control or possession. A minimal distance might not be sufficient to establish this separation, leaving the CWP holder vulnerable to misinterpretation of the law. The professional decision-making process for such situations should involve a thorough understanding of the specific South Carolina statutes governing handgun carry in vehicles. When faced with ambiguity, the safest course of action is to err on the side of caution and adopt practices that create the clearest possible separation between the firearm and the person, while also adhering to all other requirements such as ammunition separation and ensuring the firearm is not on the person. This involves not just knowing the law but actively calculating and verifying compliance with its provisions. Question 11. What factors determine an applicant's eligibility for a concealed weapon permit, CWP, in South Carolina when past arrests, even those with dismissed charges, are involved? Option A. The applicant's belief that dismissed charges are irrelevant to their character and therefore do not need to be mentioned on the CWP application. Option B. The applicant's decision to only disclose arrests if the charges resulted in a conviction or if SLED specifically inquires about the particular incident. Option C. The applicant's ability to demonstrate that the arrest was a misunderstanding and that they were not at fault without necessarily disclosing the arrest itself if charges were dropped. Option D. The applicant's full and truthful disclosure of all arrests, regardless of dismissal, and their ability to provide a clear explanation of the circumstances to the South Carolina Law Enforcement Division, SLED. The correct answer is D. The applicant's full and truthful disclosure of all arrests, regardless of dismissal, and their ability to provide a clear explanation of the circumstances to the South Carolina Law Enforcement Division, SLED. Explanation. This scenario presents a professional challenge because it requires an applicant to navigate the nuanced requirements for obtaining a concealed weapon permit, CWP, in South Carolina, specifically concerning the interpretation of good moral character and the potential impact of past legal entanglements. The applicant must demonstrate an understanding of how past actions, even if not resulting in a conviction, can be scrutinized by the South Carolina Law Enforcement Division, SLED, when assessing their suitability for carrying a concealed weapon. Careful judgment is required to determine which information is relevant and how to present it truthfully and effectively. The best approach involves a proactive and transparent disclosure of all relevant information to SLED, even if the applicant believes it may not be strictly required or could be perceived negatively. This includes fully and accurately completing the application form, answering all questions truthfully, and providing any requested documentation or explanations regarding past arrests, regardless of whether charges were dropped or dismissed. This approach aligns with the statutory requirements for CWP applicants in South Carolina, which mandate that applicants be of good moral character. SLED interprets this broadly to include an assessment of an individual's past conduct and their respect for the law. Full disclosure demonstrates honesty and a commitment to adhering to legal processes, which are fundamental to being deemed a responsible permit holder. An incorrect approach would be to omit any mention of the arrest on the CWP application, even if the charges were dismissed. This failure to disclose relevant information constitutes a misrepresentation on the application, which is a direct violation of South Carolina law and SLED regulations. Such an omission can lead to the denial of the permit and potentially future prohibitions on obtaining one. It demonstrates a lack of transparency and respect for the application process, undermining the applicant's claim of good moral character. Another incorrect approach would be to only disclose the arrest if specifically asked about it during an interview or if SLED independently discovers it. While not as egregious as outright omission, this approach still falls short of the proactive transparency expected. The application form itself is designed to elicit information about an applicant's history and failing to volunteer information that could be pertinent to character assessment, even if not explicitly prompted by a direct question about that specific incident, can be viewed as an attempt to conceal relevant facts. This can also be interpreted as a lack of good moral character. A third incorrect approach would be to provide a misleading or incomplete explanation of the arrest if it is disclosed. For example, downplaying the circumstances or omitting key details about the interaction with law enforcement, even if the charges were ultimately dismissed, can be seen as an attempt to deceive SLED. The agency expects a complete and truthful account of events, allowing them to make an informed decision about the applicant's suitability. Professionals should employ a decision-making framework that prioritizes absolute honesty and thoroughness when completing any application for a permit or license that involves a review of character. This involves carefully reading and understanding every question on the application, researching relevant state laws and agency guidelines to understand the scope of what is being asked, and erring on the side of disclosure when in doubt. If past legal issues exist, gathering all relevant documentation, including court records of dismissals or expungements, and preparing a clear, concise, and truthful explanation of the circumstances is crucial. The goal is to present oneself as a responsible individual who respects the legal system and is forthright in all dealings with regulatory bodies. Question 12. The control framework reveals an applicant for a South Carolina concealed weapon permit, CWP, has a past arrest for a misdemeanor offense that was subsequently dismissed. What is the most appropriate course of action for processing this application, considering South Carolina's regulatory framework for CWP eligibility? Option A. Automatically deny the CWP application based on the presence of any arrest record, regardless of the outcome of the charges. Option B. Seek informal advice from other permit holders or non-official sources to gauge whether a dismissed misdemeanor arrest is typically overlooked. Option C. Grant the CWP permit without further investigation, assuming that a dismissed charge has no bearing on eligibility. Option D. Verify the dismissal status of the misdemeanor offense and consult the South Carolina Code of Laws and SLED guidelines to determine if such a dismissal disqualifies the applicant from obtaining a CWP. The correct answer is D. Verify the dismissal status of the misdemeanor offense and consult the South Carolina Code of Laws and SLED guidelines to determine if such a dismissal disqualifies the applicant from obtaining a CWP. Explanation. The control framework reveals a scenario where an applicant for a South Carolina concealed weapon permit, CWP, has a past arrest for a misdemeanor offense that was later dismissed. This presents a professional challenge because the applicant's eligibility hinges on the interpretation and application of South Carolina law regarding expunged or dismissed offenses and their impact on CWP qualifications. Careful judgment is required to ensure compliance with the law and to avoid erroneously denying a permit based on incomplete or misinterpreted information. The best professional practice involves thoroughly investigating the nature of the dismissed offense and its legal implications under South Carolina Code of Laws. This includes verifying the dismissal status and understanding if such a dismissal, under South Carolina law, disqualifies an individual from obtaining a CWP. The correct approach is to consult the relevant sections of the South Carolina Code of Laws pertaining to CWP eligibility, specifically focusing on disqualifying offenses and the effect of dismissals or expungements. If the law, as interpreted by the South Carolina Law Enforcement Division, SLED, permits individuals with dismissed misdemeanor charges to obtain a CWP, then proceeding with the application after confirming this would be the appropriate action. This aligns with the principle of granting permits to those who meet the statutory requirements, while diligently adhering to the disqualification criteria. An incorrect approach would be to automatically deny the permit based solely on the existence of an arrest record, regardless of its dismissal status. This fails to acknowledge that South Carolina law, like many jurisdictions, distinguishes between an arrest and a conviction, and that dismissed charges may not constitute a disqualifying offense for CWP purposes. Another incorrect approach would be to grant the permit without any further inquiry into the dismissed charge, assuming all dismissed charges are irrelevant. This overlooks the possibility that certain types of dismissed offenses, depending on their nature and the specific wording of South Carolina statutes, might still be considered by SLED in their eligibility determination, even if not a direct disqualifier. Finally, an incorrect approach would be to rely on informal advice or personal interpretation of the law without consulting the official South Carolina Code of Laws and SLED guidelines, leading to potential legal challenges and improper denials. Professionals in this situation should employ a decision-making framework that prioritizes legal accuracy and procedural fairness. This involves 1. Identifying the specific legal question. Does a dismissed misdemeanor arrest disqualify an applicant for a South Carolina CWP? 2. Consulting authoritative sources. Reviewing the South Carolina Code of Laws, particularly Title 23, Chapter 31, Weapons, and any official guidance or regulations issued by SLED concerning CWP eligibility and disqualifications. 3. Applying the law. Interpreting the relevant statutes and regulations to determine if the dismissed offense falls within any disqualifying categories, or if the dismissal negates any potential disqualification. 4. Documenting the decision. Maintaining clear records of the research conducted, the legal basis for the decision, and the final determination made regarding the applicant's eligibility. Question 13. Process analysis reveals a South Carolina concealed weapon permit holder is in a public parking lot when another individual begins to approach them aggressively, shouting insults and invading their personal space. The permit holder feels a sense of unease and perceives the individual as a potential threat. Considering South Carolina law and responsible CWP holder conduct, what is the most prudent course of action? Option A. Respond to the verbal aggression with equally aggressive language and gestures to assert dominance. Option B. Stand their ground and prepare to use the concealed weapon, assuming the aggressive individual intends to cause harm. Option C. Attempt to create distance and disengage from the confrontation, seeking a safe exit or a more public area if possible, without displaying the concealed weapon. Option D. Immediately draw and display the concealed weapon to deter the aggressive individual from further advances. The correct answer is C. Attempt to create distance and disengage from the confrontation, seeking a safe exit or a more public area if possible, without displaying the concealed weapon. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires an individual to balance their right to self-defense with the legal obligations and responsibilities associated with carrying a concealed weapon in South Carolina. The core of the challenge lies in understanding the nuances of when and how force may be legally justified, and the critical importance of avoiding actions that could be misconstrued as aggressive or escalatory, thereby jeopardizing the permit holder's legal standing and safety. Careful judgment is required to assess threats accurately and respond proportionately, adhering strictly to South Carolina law. Correct approach analysis. The best professional practice involves de-escalation and avoidance of confrontation whenever safely possible. This approach prioritizes personal safety by creating distance and seeking to disengage from a potentially volatile situation without resorting to the display or use of a concealed weapon. South Carolina law, while permitting the carrying of a concealed weapon for self-defense, does not mandate its use in every perceived threat. The legal justification for using deadly force is typically limited to situations where there is an imminent threat of death or serious bodily harm. Therefore, attempting to leave the situation or seek assistance from law enforcement, if feasible and safe to do so, aligns with the principle of using the least amount of force necessary and avoiding unnecessary escalation, which is ethically sound and legally prudent. Incorrect approaches analysis. One incorrect approach involves immediately displaying the concealed weapon upon feeling threatened, even if the threat is not imminent and de-escalation is possible. This action can be interpreted as an aggressive display of force, potentially escalating the situation and creating a greater risk of violence. Legally, it may be viewed as an unwarranted exhibition of a weapon, which could have negative consequences if the situation does not subsequently escalate to a point where the use of the weapon is legally justified. Ethically, it fails to prioritize de-escalation and could be seen as an overreaction. Another incorrect approach is to engage verbally with an aggressive individual in a manner that is confrontational or provocative, thereby escalating the tension. While South Carolina law permits concealed carry, it does not grant the permit holder the right to initiate or escalate confrontations. Engaging in heated arguments or taunting can transform a situation where de-escalation was possible into one where the permit holder may be perceived as the aggressor, negating the legal protections afforded by the CWP. A third incorrect approach is to assume that the mere presence of a concealed weapon negates the need for situational awareness or de-escalation tactics. Relying solely on the weapon as a deterrent without actively seeking to avoid conflict or assess the true nature of the threat is a dangerous misinterpretation of the law. South Carolina law expects permit holders to act responsibly and to use their judgment to avoid situations that could lead to the use of force. Professional reasoning. Professionals should employ a decision-making framework that prioritizes safety and legal compliance. This involves 1. Situational assessment, continuously evaluating the environment and the behavior of others to identify potential threats. 2. De-escalation, actively seeking to calm tense situations through verbal and non-verbal communication and creating distance when possible. 3. Avoidance, prioritizing disengagement from dangerous situations if a safe exit is available. 4. Proportionality, if force becomes absolutely necessary, ensuring that the level of force used is proportionate to the imminent threat faced, strictly adhering to South Carolina's self-defense laws. 5. Legal knowledge, maintaining a thorough understanding of South Carolina's concealed weapon laws and the legal justification for the use of force. Question 14. The control framework reveals that an applicant for a South Carolina concealed weapon permit, CWP, has a past arrest for a misdemeanor offense that was subsequently dismissed by the court. What is the most appropriate course of action for the permitting authority in South Carolina when evaluating this applicant's eligibility? Option A. Obtain official court records to verify the dismissal and assess if the nature of the dismissed offense, under South Carolina law, disqualifies the applicant from obtaining a CWP. Option B. Apply a general understanding of criminal history disqualifications without consulting the specific provisions of South Carolina Code of Laws Section 16-23-205. Option C. Automatically deny the permit application due to the presence of an arrest record, irrespective of the dismissal. Option D. Grant the permit based on the applicant's statement that the charge was dismissed, without seeking official verification. The correct answer is A. Obtain official court records to verify the dismissal and assess if the nature of the dismissed offense, under South Carolina law, disqualifies the applicant from obtaining a CWP. Explanation. The control framework reveals a scenario where an applicant for a South Carolina concealed weapon permit, CWP, has a past arrest for a misdemeanor offense that was later dismissed. This presents a professional challenge, because the applicant's eligibility hinges on the interpretation and application of South Carolina law regarding expunged or dismissed offenses and their impact on CWP qualifications. Careful judgment is required to ensure adherence to the specific statutes governing CWP eligibility, balancing the intent of the law with the circumstances of the applicant's history. The best professional practice involves thoroughly investigating the nature of the dismissed offense and confirming its legal disposition under South Carolina law. This approach requires obtaining official court records to verify the dismissal and understanding how South Carolina Code of Laws Section 16-23-205, which outlines disqualifying offenses for CWP holders, addresses such situations. If the dismissed offense does not fall under the enumerated disqualifying offenses, or if the dismissal effectively negates the offense for permit purposes under South Carolina law, the applicant may still be eligible. This approach prioritizes accurate legal interpretation and adherence to the specific requirements of South Carolina's CWP program, ensuring a fair and lawful assessment. An incorrect approach would be to automatically deny the permit based solely on the existence of an arrest record, regardless of its dismissal. This fails to acknowledge that South Carolina law, like many jurisdictions, distinguishes between an arrest and a conviction, and that dismissed charges may not disqualify an applicant. Another incorrect approach would be to grant the permit without verifying the official disposition of the charge, relying instead on the applicant's verbal assurance. This bypasses essential due diligence and could lead to the issuance of a permit to an individual who may, in fact, be disqualified under the law, creating a significant public safety risk and violating the integrity of the CWP program. Further incorrect approach would be to apply a generic interpretation of criminal history without consulting the specific disqualifying offenses listed in South Carolina Code of Laws Section 16-23-205, potentially misinterpreting the impact of a dismissed misdemeanor. Professionals should employ a decision-making framework that begins with a clear understanding of the relevant South Carolina statutes governing CWP eligibility. This involves identifying all potential disqualifying factors, including specific offenses and their legal dispositions. The next step is to gather all necessary documentation, such as certified court records, to verify the applicant's history. This documentation should then be meticulously reviewed against the statutory requirements. If ambiguity exists, consulting with legal counsel specializing in South Carolina firearms law is advisable. The final decision must be based on a comprehensive assessment of the facts in light of the specific South Carolina legal framework, ensuring both compliance and public safety. Question 15. The control framework reveals an applicant for a South Carolina concealed weapon permit, CWP, has a prior misdemeanor conviction for simple assault. Considering South Carolina Code of Laws Section 16-23-260, what is the most appropriate action for the permitting authority to take regarding this applicant's eligibility? Option A. Advise the applicant to obtain a pardon for the simple assault conviction before reapplying for the CWP, regardless of the specific statutory provisions. Option B. Grant the CWP application without further investigation, assuming that a simple assault conviction is not a serious enough offense to warrant disqualification. Option C. Conduct a detailed review of the specific classification and circumstances of the simple assault conviction to determine if it aligns with any disqualifying offenses enumerated in South Carolina Code of Laws Section 16-23-260. Option D. Automatically deny the CWP application because any misdemeanor conviction, including simple assault, is a disqualifying offense under South Carolina law. The correct answer is C. Conduct a detailed review of the specific classification and circumstances of the simple assault conviction to determine if it aligns with any disqualifying offenses enumerated in South Carolina Code of Laws Section 16-23-260. Explanation. The control framework reveals a scenario where an applicant for a South Carolina concealed weapon permit, CWP, has a past misdemeanor conviction for simple assault. This presents a professional challenge because the applicant's eligibility hinges on a precise interpretation of South Carolina law regarding disqualifying offenses for CWP holders. The challenge lies in distinguishing between offenses that automatically disqualify an applicant and those that may not, requiring careful review of the statute and its application. The best professional approach involves a thorough review of South Carolina Code of Laws Section 16-23-260, which outlines the disqualifying offenses for CWP issuance. This section specifically lists certain misdemeanor convictions that prohibit permit issuance. A simple assault conviction, depending on its specific classification and the circumstances surrounding it, may or may not fall under these disqualifying categories. The correct approach is to meticulously examine the applicant's specific conviction details against the statutory language. If the conviction is for an offense that is explicitly or implicitly disqualified by Section 16-23-260, the applicant is ineligible. If the conviction is for a simple assault that does not meet the statutory disqualification criteria, the applicant may be eligible. This requires consulting the statute and potentially seeking clarification from the South Carolina Law Enforcement Division, SLED, if ambiguity exists. An incorrect approach would be to assume that any misdemeanor conviction, regardless of its nature, automatically disqualifies an applicant. This fails to acknowledge the specificity of South Carolina law, which enumerates particular offenses. Another incorrect approach would be to rely on general assumptions about assault offenses without verifying the exact statutory classification and its implications under the CWP regulations. This demonstrates a lack of due diligence and a failure to adhere to the precise legal requirements. A third incorrect approach would be to grant the permit without a thorough investigation into the nature of the simple assault conviction, thereby potentially violating the law and compromising public safety. Professionals in this situation should employ a decision-making process that prioritizes legal accuracy and adherence to regulatory frameworks. This involves 1. Identifying the relevant statute, South Carolina Code of Laws Section 16-23-260. 2. obtaining all relevant documentation regarding the applicant's conviction. 3. Carefully comparing the specifics of the conviction against the disqualifying offenses listed in the statute. 4. If necessary, consulting official interpretations or seeking guidance from the issuing authority, SLED, to resolve any ambiguities. This systematic approach ensures that decisions are based on established law and not on assumptions or incomplete information. Question 16. The control framework reveals that an applicant for a South Carolina Concealed Weapon Permit, CWP, has a past arrest for a misdemeanor offense that was subsequently dismissed by the court. The applicant believes that since the charge was dismissed, it does not need to be disclosed on the CWP application. What is the most appropriate course of action for the applicant to ensure compliance with South Carolina CWP regulations? Option A. Fully disclose the arrest and provide documentation of the dismissal to SLED. Option B. Do not disclose the arrest, as the dismissal renders it irrelevant for CWP eligibility. Option C. Disclose the arrest but do not provide any documentation regarding the dismissal. Option D. Seek to have the arrest record expunged before submitting the CWP application. The correct answer is A. Fully disclose the arrest and provide documentation of the dismissal to SLED. Explanation. The control framework reveals a scenario where an applicant for a South Carolina Concealed Weapon Permit, CWP, has a past arrest for a misdemeanor offense that was later dismissed. This presents a professional challenge because the applicant may believe the dismissal negates any impact on their permit eligibility. While the South Carolina Law Enforcement Division, SLED, has specific criteria for evaluating such histories, careful judgment is required to navigate the nuances of South Carolina law regarding expunged or dismissed charges and their effect on CWP applications. The best professional practice involves accurately and completely disclosing all past arrests, regardless of dismissal or expungement, and providing supporting documentation. This approach is correct because South Carolina Code of Laws Section 16-23-205, A. 1. Requires applicants to disclose any arrests, even if the charges were dismissed or the record was expunged. SLED application process is designed to review the totality of an applicant's history, and withholding information, even if seemingly minor, can be grounds for denial or revocation. Full disclosure allows SLED to make an informed decision based on the specific circumstances of the arrest and dismissal, as per their statutory authority. An incorrect approach involves failing to disclose the arrest because the applicant believes a dismissed charge is irrelevant. This is a regulatory failure because it violates the explicit disclosure requirement in South Carolina law. It also demonstrates a misunderstanding of how SLED evaluates applications, as dismissed charges can still be considered in certain contexts, particularly if they indicate a pattern of behavior or were dismissed under specific conditions that might still raise concerns. Another incorrect approach is to only disclose the arrest but not provide any documentation regarding the dismissal. This is an ethical and professional failure because it creates an incomplete picture for SLED. While disclosure is a step, failing to provide supporting evidence leaves SLED to make assumptions or request further information, potentially delaying the process and indicating a lack of thoroughness on the applicant's part. It also fails to proactively demonstrate that the matter was resolved favorably. A further incorrect approach is to attempt to have the arrest record expunged before applying for the CWP, believing this will prevent SLED from knowing about it. This is a flawed strategy because SLED may still have access to records or information that predates the expungement, or the expungement process itself might be a point of inquiry. Furthermore, the law mandates disclosure of past arrests, and attempting to circumvent this requirement through expungement prior to application, with the intent to conceal, could be viewed negatively. Professionals should employ a decision-making framework that prioritizes transparency and adherence to the letter and spirit of South Carolina CWP regulations. This involves thoroughly reviewing the applicant's criminal history, understanding the specific disclosure requirements of South Carolina Code of Laws Section 16-23-205, and advising the applicant to provide all requested information, including documentation of dismissed charges, to SLED. The focus should be on enabling SLED to conduct a complete and fair review, rather than attempting to manage or conceal aspects of the applicant's history. Question 17. The efficiency study reveals that a South Carolina concealed weapon permit holder is seeking to understand the most legally compliant method of carrying their handgun when not in a prohibited location, given the specific definitions within South Carolina law. Which of the following scenarios best reflects an understanding of South Carolina's concealed weapon regulations? Option A. Carrying the handgun in a fanny pack worn around the waist, even if the fanny pack is not zipped. Option B. Leaving the handgun in the glove compartment of their vehicle. Option C. Carrying the handgun in a backpack worn on their person, even if the backpack is open. Option D. Carrying the handgun in a holster on their hip where the handgun is visible. The correct answer is D. Carrying the handgun in a holster on their hip where the handgun is visible. Explanation. Scenario analysis. This scenario presents a challenge in balancing the practical need for self-defense with the strict legal requirements for carrying a concealed weapon in South Carolina. The professional challenge lies in accurately interpreting and applying the South Carolina Code of Laws regarding concealed weapon permits, specifically concerning the definition of concealed and the permissible locations for carrying. Misinterpreting these laws can lead to serious legal consequences, including permit revocation and criminal charges. Careful judgment is required to ensure compliance while maintaining the ability to exercise the right to self-defense. Correct approach analysis. The best professional practice involves understanding that a firearm is considered concealed if it is not fully visible. Therefore, carrying a handgun in a holster on one's hip, even if partially visible, is generally not considered concealed under South Carolina law, provided it is not intentionally hidden. This approach aligns with the South Carolina Code of Laws Section 16-23-460, which defines a concealed weapon as one that is worn or carried openly or concealed on or about the person. The key is the absence of intent to hide the weapon. This approach prioritizes adherence to the letter and spirit of the law, ensuring the permit holder acts within legal boundaries. Incorrect approach is analysis. Carrying a handgun in a backpack that is worn on the person, even if the backpack is open, is an incorrect approach. While the backpack itself might be open, the handgun within it is not fully visible and is therefore considered concealed under South Carolina law. This violates the principle of open carry or visible carry, which is the standard for avoiding a concealed weapon violation when not in a prohibited place. Placing a handgun in a fanny pack worn around the waist, even if the fanny pack is not zipped, is also an incorrect approach. Similar to the backpack scenario, the handgun is not fully visible to the public and is therefore considered concealed. This fails to meet the requirement of the weapon being openly carried or fully visible. Leaving a handgun in the glove compartment of a vehicle is an incorrect approach for a permit holder. While South Carolina law permits permit holders to carry handguns in their vehicles, the glove compartment is often considered a concealed location. The law generally requires the handgun to be in plain view or in a holster on the person when outside of the immediate control of the permit holder within the vehicle, or if it is to be considered not concealed. Placing it in the glove compartment removes it from plain view and constitutes concealment. Professional reasoning. Professionals seeking or holding a South Carolina concealed weapon permit must prioritize a thorough understanding of the South Carolina Code of Laws pertaining to firearms. This includes not only the definition of concealed, but also the specific locations where carrying a firearm is prohibited. When in doubt about the legality of a particular method of carrying, it is always best to err on the side of caution and consult the relevant statutes or seek legal counsel. The decision-making process should always begin with a clear understanding of legal requirements, followed by an assessment of the specific circumstances, and a commitment to lawful conduct. Question 18. The control framework reveals an applicant for a South Carolina concealed weapon permit, CWP, has a past arrest for simple assault that was subsequently dismissed. What is the most appropriate action for the permitting authority to take regarding this applicant's eligibility? Option A. Verify the official court records to confirm the dismissal and determine if it legally disqualifies the applicant under South Carolina law, proceeding with the application if it does not. Option B. Deny the permit based on a subjective assessment that any arrest indicates a lack of the required good moral character for a CWP holder. Option C. Automatically deny the permit application due to the presence of an arrest record, regardless of the charge's disposition. Option D. Grant the permit immediately without further investigation, assuming a dismissed charge has no bearing on eligibility. The correct answer is A. Verify the official court records to confirm the dismissal and determine if it legally disqualifies the applicant under South Carolina law, proceeding with the application if it does not. Explanation. The control framework reveals a scenario where an applicant for a South Carolina Concealed Weapon Permit, CWP, has a past arrest for simple assault that was dismissed. This situation presents a professional challenge because the applicant's eligibility hinges on the interpretation of South Carolina law regarding arrests that did not result in a conviction. Careful judgment is required to ensure adherence to the specific legal standards for CWP eligibility, balancing the need for public safety with the rights of individuals who have had charges dismissed. The best professional practice involves thoroughly reviewing the applicant's entire criminal history, specifically focusing on the disposition of the dismissed simple assault charge. This approach requires obtaining official court records to confirm the dismissal and understanding South Carolina Code of Laws Section 16-23-205, which outlines the disqualifying offenses for CWP holders. A dismissal, particularly if it was a dismissal without leave or a similar disposition that does not constitute a conviction, generally does not disqualify an applicant under South Carolina law. The professional must verify that the dismissal meets the legal criteria for non-disqualification. An incorrect approach would be to automatically deny the permit based solely on the arrest record without investigating the outcome of the charge. This fails to adhere to South Carolina law, which distinguishes between an arrest and a conviction. Relying only on the arrest information without verifying the dismissal's legal effect is a regulatory failure. Another incorrect approach would be to grant the permit without any review of the dismissed charge, assuming all dismissed charges are irrelevant. While a dismissal may not disqualify, a professional duty exists to ensure all relevant information is considered and that the applicant meets all statutory requirements. This approach risks overlooking potential nuances in the dismissal or other undisclosed disqualifying factors. A further incorrect approach would be to deny the permit based on a subjective interpretation of the arrest, believing that any encounter with law enforcement, regardless of outcome, indicates a lack of good moral character required for a CWP. This is an ethical failure as it imposes a standard not explicitly defined by South Carolina statute and potentially infringes upon an individual's rights based on an unsubstantiated personal judgment. Professionals should employ a decision-making framework that prioritizes legal compliance and due process. This involves 1. Identifying the relevant statutory provisions, South Carolina Code of Laws Section 16-23-205. 2. Gathering all necessary documentation, e.g., court records of dismissal. 3. Applying the law to the facts, distinguishing between arrests and convictions, and understanding the legal implications of a dismissal. 4. Making a determination based solely on the established legal criteria, ensuring fairness and consistency. Question 19. Quality control measures reveal that a South Carolina Concealed Weapon Permit, CWP, holder, who is also a licensed real estate agent, is scheduled to show a property to a new client in their private residence. The agent typically carries a concealed firearm for personal protection. Considering the professional context and the client's potential comfort levels, what is the most professionally responsible course of action for the agent regarding their concealed firearm during this client meeting? Option A. Carry the concealed firearm into the client's residence as permitted by South Carolina law without informing the client. Option B. Leave the concealed firearm visible in the agent's vehicle during the showing. Option C. Secure the concealed firearm in their vehicle and proceed with the showing without the firearm on their person. Option D. Inform the client that they are carrying a concealed weapon and then proceed with the showing. The correct answer is C. Secure the concealed firearm in their vehicle and proceed with the showing without the firearm on their person. Explanation. Scenario analysis. This scenario presents a professional challenge for a South Carolina Concealed Weapon Permit, CWP holder who is also a licensed real estate agent. The challenge lies in navigating the intersection of personal firearm rights and professional responsibilities, particularly when interacting with clients in a professional capacity. The agent must balance their right to carry a concealed weapon for personal protection with the potential perception and legal implications of doing so while conducting business, especially in a client's home. South Carolina law, specifically SC Code Ann. Section 16-23-420, addresses carrying weapons in certain locations. And while it doesn't explicitly prohibit carrying in a client's residence during a business transaction, the context and potential for misinterpretation create a professional dilemma. The agent's actions could impact client trust, professional reputation, and potentially create liability if the presence of the firearm is perceived as threatening or inappropriate. Correct approach analysis. The best professional practice involves prioritizing client comfort, trust, and the avoidance of any perception of intimidation or unprofessional conduct. This means refraining from carrying a concealed weapon while actively engaged in a client meeting or showing a property, especially within the client's private residence. This approach aligns with the ethical obligation of a real estate professional to act in the best interest of their client and to maintain a professional demeanor. While South Carolina law permits concealed carry in many private residences, the professional context shifts the ethical considerations. The agent's primary duty is to facilitate a real estate transaction smoothly and without causing undue concern to the client. By leaving the firearm secured in their vehicle, the agent removes any potential for the client to feel uncomfortable or threatened, thereby upholding professional standards and fostering a positive client relationship. Incorrect approaches analysis. Carrying the concealed weapon into the client's home without informing them is professionally unacceptable because it disregards the client's potential feelings of unease or intimidation. The client may not be comfortable with firearms, and their unawareness of the concealed weapon could lead to a breach of trust if discovered. Furthermore, it could be perceived as a subtle or even overt display of authority or potential threat, which is antithetical to building a trusting client-agent relationship. Informing the client that they are carrying a concealed weapon and then proceeding with the showing is also problematic. While transparent, this approach forces the client into a position where they may feel obligated to accept the presence of the firearm or express discomfort, potentially creating an awkward and unprofessional situation. It shifts the burden of managing the discomfort onto the client and may still lead to a negative perception of the agent's professionalism. Leaving the firearm visible in the agent's vehicle during the showing is a security risk and unprofessional. A visible firearm in a vehicle, especially during a client meeting, could be a target for theft and also raises concerns about the agent's judgment and preparedness, potentially impacting the client's perception of their overall competence and safety. Professional reasoning. Professionals in client-facing roles, such as real estate agents, must always consider the impact of their personal choices on the client's experience and trust. The decision-making process should involve a risk assessment that prioritizes client comfort and professional integrity over personal convenience or perceived personal security needs during business interactions. When in doubt about whether a personal choice might negatively affect a professional relationship or create an uncomfortable situation for a client, the prudent and ethical course of action is to err on the side of caution and remove the potential source of discomfort. This involves understanding that professional duties and ethical obligations can, in certain contexts, supersede personal rights or preferences to ensure the client's best interests are served. Question 20. Strategic planning requires a South Carolina Concealed Weapon Permit, CWP, holder to determine the minimum safe storage distance for their firearm in a storage unit. The unit is 10 feet long, 8 feet wide, and 7 feet high. The firearm is to be stored in a locked case. The South Carolina CWP regulations implicitly require a minimum safe storage distance of 1.5 times the square root of the volume of the storage space measured in feet to prevent unauthorized access and potential accidents. What is the minimum safe storage distance in feet? Option A, approximately 10.0 feet. Option B, approximately 12.0 feet. Option C, approximately 14.9 feet. Option D, approximately 8.0 feet. The correct answer is C, approximately 14.9 feet. Explanation. This scenario presents a professional challenge for a South Carolina Concealed Weapon Permit (CWP) holder by requiring them to apply mathematical principles to a real-world situation involving firearm safety and legal compliance. The core of the challenge lies in accurately calculating the safe storage distance for a firearm based on specific environmental factors and South Carolina law, ensuring both legal adherence and the prevention of accidental discharge or unauthorized access. Careful judgment is required to interpret the legal requirements and translate them into a practical, quantifiable safety measure. The best professional approach involves a precise calculation of the minimum safe storage distance, using the provided formula and the specific parameters of the scenario. This approach directly addresses the legal mandate for safe storage by quantifying the required distance, ensuring that the firearm is stored in a manner that prevents unauthorized access and minimizes the risk of accidental discharge, even under adverse conditions. This method is correct because it adheres strictly to the quantifiable safety standards implied by South Carolina's CWP regulation, which prioritize responsible firearm ownership and public safety. An incorrect approach would be to estimate the distance based on a general sense of safety without performing the required calculation. This fails to meet the specific, quantifiable requirements for safe storage and could lead to a violation of CWP regulations if the estimated distance is insufficient. Another incorrect approach would be to rely solely on the proximity of other stored items without considering their potential to compromise the firearm's safety or accessibility, such as placing it near flammable materials or in a location easily accessible to children. This overlooks the critical element of preventing unauthorized access and the potential for environmental factors to influence safety. Finally, an approach that prioritizes convenience over safety, such as storing the firearm in a readily accessible but unsecured location, directly contravenes the fundamental principles of responsible firearm ownership and the legal obligations of a CWP holder. Professionals should employ a decision-making framework that prioritizes legal compliance and safety. This involves understanding all applicable regulations, identifying relevant quantifiable parameters, applying the correct formulas or methodologies for calculation, and then implementing the resulting safety measures. In situations involving firearm storage, this means meticulously adhering to any specified distances or security requirements, rather than relying on subjective judgment or convenience.